At no point ever has it been this difficult to manage our apartment buildings. And what we're going to do is interview Oliver John Baptiste with the Apartment Association. He's going to shed some light on new forms, our new laws and tips moving forward so that you have all the tools at your disposal to better manage your apartment buildings. Hi, I'm Juan Huizar, president of Sage Real Estate, your multifamily market leader. Today, we're going to be talking about the new laws that are impacting us coming 2021. The goal at Sage Real Estate is to educate our apartment owners, to keep you up to date on all the changes, keep you up to date on all the forms that are required, the things that are happening that are going to impact the way that you own and manage your apartment buildings, give you all the information so that you make the best decision when it comes to your business, to your retirement. Who is Oliver John Baptiste? Oliver John Baptiste works for the Apartment Association. He's a terrific source for anything having to do with landlord-tenant questions. We reached out to Oliver because Oliver takes in calls every single day from people like us, apartment owners in the city of Long Beach who have questions, who have concerns. And so Oliver is taking these calls every single day. And the purpose of today is, what are the most frequently asked questions from landlords? What are they asking? What are their thoughts? What are they worried about? Their concerns? And Oliver's gonna go through that today. Today we talked about the eviction moratorium. It's set to expire January 30th of 2021. There's talks about it being extended. We talked about rental increases. We talked about if you're an owner and you want possession of your apartment building, can you move into one of the units, which is a question that he gets asked often. We talked about a payback plan with your tenant and kind of how to coordinate that. We talked about the 15-day notice to kick off an unlawful detainer, which right now you are able to start. We talked about substantial nuisance that a tenant is causing in your building and how to handle that. He gave us some of the tips moving forward that he would recommend owners pay attention to. And then also he highlighted a few of the forms that are new through the Apartment Association and ones that are required, and also talked about how the contract is now much longer. So please tune in because there's a lot of good information, but things that are gonna allow you to better manage your apartment buildings. One of the important items that we spoke about today is how, obviously it's confusing right now to be an apartment owner. It's probably the most confusing time that we've ever had to deal with. So, but a part of the confusion is that there's Long Beach, there's LA City, then there's LA County. So oftentimes we'll hear something in the news that LA County passed this rule, either protecting the tenants or either giving the landlord new restrictions. And we as apartment owners need to realize, well, where's my property located and does that impact me? And that's where our company, Sage Real Estate, we're here as a resource. We're keeping up to date on all the changes impacting apartment owners like yourselves. And also we recommend that you reach out to the Apartment Association, and certainly Oliver John Baptiste is a terrific source to keep you guys up to date. But there's a difference between Long Beach, LA City, and LA County, and at times they might have all the same laws, or at times one of those passes new laws that doesn't apply to the rest. So it's important to know where you're at and what's applicable to your building. Today, we're going to highlight a lot of the new changes impacting the way that you manage your property moving forward in 2021. To me, Oliver is someone that I always count on when I have specific questions regarding tenants. What are the landlord's rights? What are tenants' rights? Especially when we're in the middle of trying to sell a building and there's a unique situation that I've not come across. Oliver is my first call, and so he's a trusted source. He does a terrific job, and I'm excited that he's going to be joining us today. Oliver, thank you for being here. Can you tell us a little bit about what you do for the Apartment Association?
Sure. So my name is Oliver John Baptiste, and I do consulting here for the Apartment Association. And that entails me talking on a daily basis to property owners, realtors, brokers, a variety of stakeholders in the rental housing industry. And it's really been a trial, more or less a trial by fire or anything, learning or anything through the experiences of property owners, realtors or anything, especially in 2020 with AB 3088, COVID-19 moratoriums. So that's really what I do here at the association, is helping property owners, realtors, and stakeholders in the industry navigate the complexities of the rental housing industry.
Thank you for all that you do, Oliver. You're taking in, I don't know how many calls you take in a day, Oliver, but I know sometimes I can't get a hold of you because you're so busy. So what I'd like to ask you is, what are the top, say, 5 questions that you're being asked frequently by apartment owners?
I would say in order of popularity or importances, navigating AB 3088. So AB 3088 is a recent piece of legislation enacted on August 31st. And this provided a degree of protection for tenants or anything regarding the accrued rent during this COVID-19 period. Now, AB 3088 expires on January 31st of 2021. So that piece of legislation, understanding that alongside the local moratoriums. So there have been a number of local moratoriums as well, whether it be in Los Angeles County, specifically the city of Los Angeles, Orange County. So I think that's more or less been more at the macro level, if you will, for many owners or anything. How do I understand the interaction between the federal law, the CDC law, the state law, AB 3088, and local moratoriums? Now, alongside that or anything, I would say rent increases or anything is another popular question. Obviously, with AB 3088, that's put the question of rent increases much more in the forefront of many owners' minds. So right now, the only city with a rent freeze is the city of Los Angeles. Now, there's currently a lawsuit being filed against the city of Los Angeles by AGLA, the Apartment Association of Greater Los Angeles. And one of their arguments is that whereas Los Angeles County, for example, has a definite termination date in the moratorium, January 31st, there is no specific termination date for the city of Los Angeles. It is more or less when the local moratorium is lifted by city council approval. So there is no definite end date. So the city of Los Angeles is one city where there's an existing rent freeze, and that is only for RSO properties. RSO properties are duplexes, and above or anything. Single-family homes are exempt from local rent control in the city of Los Angeles. Now, alongside rent control, rent increase questions also, we have another piece of legislation that came out in January of 2020. This was AB 1482. And as many of you remember, I think there was much consternation about this new piece of legislation. In a nutshell, it's made up of two pillars. One is a just cause protection that tenants gain after occupying a unit after 12 months' time. And the second portion is a rent cap. And the rent cap applies to only certain subject properties, and that rent cap is adjusted every April. So currently the rent cap is at 5.6%. And those properties that are subject are, say, duplexes and above or anything can raise rents at that level. Now, normally a single family home, a condo, or say a townhouse would be exempt from AB 1482. So there would be no limit in terms of rent increases. But temporarily, due to the state of emergency, there is a 10%, let's just say, state of emergency cap currently in existence. So just to take a bit of a breathing room there, I think that's probably the primary question, I guess, of concern for many owners or anything. With the pressure of these competing legislations on my back, rent increase is obviously a big question at the moment.
Okay, so let me recap on those. So there was kind of two components in terms of questions that you're getting constantly. And I think the first one would be having to do with the eviction moratorium, which is currently in place. So that was the first part. And then the second part was the rent control law that was passed in the beginning of the year, putting a cap on the increases that a landlord could put on. Is that correct?
Exactly, I think. So more or less in descending order, it's understanding these competing pieces of legislation, whether it be AB 3088 or the local moratorium. And now once owners more or less grapple with that, now what do I do? How do I raise rents or anything? And I think as we mentioned in a previous discussion, how do I exercise my rights as a landlord? And what are my tenants' rights that I must respect at the same time?
One of the questions that I hear often from the folks that I help, the apartment owners that I help, when they're thinking about selling, they're saying, some of my tenants have stopped paying rent or they've not paid in the last 4 months. Juan, what can I do? And what advice do you have for them, Oliver? And what can they do?
So what you can do right now or anything, or rather what's been given to owners or anything, is what's under AB 3088. So right now, if you haven't done this already, you should be serving your tenants a 15-day notice to pay rent or quit, which we do have here available at the Apartment Association. So many of you are probably familiar with a 3-day notice to pay rent or quit, but temporarily, while AB 38 is in effect until January 31st, you'll be serving a 15-day notice to pay rent or quit. And that's 15 court days, so you're not counting weekends or holidays. Along with that 15-day notice, there's also a separate informational notice that you also serve along with that 15-day notice. With that notice or anything, it gives a tenant more or less two choices. The tenant can either pay the unpaid rent, or as many are choosing to do, return what's called more or less a letter of hardship, claiming with no demand of proof or anything that their income is affected by COVID-19. So many owners have been doing just that or anything, though, every month, serving their tenants when rent is due on the first of the month with a 15-day notice and seeing what the tenant's response will be. Is the tenant going to return the letter of hardship? Are they going to pay the unpaid rent? Now, if the tenant does neither, by the 16th day, you can file an unlawful detainer. Now, just to give you, I guess, a bit of frankness, right? Word from the grapevine is even if you file right now, you're anticipating a wait until at least February 1st. So many owners have done just that or anything. They've already served their tenants. The tenants have totally dropped the ball. They've filed or anything. Even with that in motion or anything, they're looking forward to a February 1st at the earliest for their case to go forward. So there's a bit of a backlog right now. On the other hand, what's also been advised by many attorneys is working on a payment plan. Now, as you know, the local moratoriums or anything, whether it be Long Beach, Los Angeles County, etc., they offered a 12-month payback plan that with tenants. So more or less how that was enacted after January 31st, for example, Los Angeles County, when that moratorium expired, tenants would have 12 months or anything to pay back unpaid rent. Now that's been superseded by AB 3088, but it is not necessarily off the table. So if you have a tenant that's more or less cooperative, they have means or anything, or they're showing you evidence that they have an ability to dig themselves out of this hole, setting up a payment plan or anything is an alternative option for landlords as well.
Okay, so let me kind of summarize what you said. Landlords are able to currently file a unlawful detainer, right?
Yes.
And what we're saying is because the moratorium for now is set to expire January 30th, technically someone could really get possession of their property starting in February. All right. I mean, if you were to go to court, and get possession of your property.
Well, that's ideally February 1st or anything, and that's very unlikely for many owners, unfortunately. So, like case in point, today's December 22nd. You're to serve your tenants on January 1st, for example. Now, under AB 3088, when tenants return that letter of hardship, there's also some additional obligation on their part. They must pay 25% of the unpaid rent, whether it be unpaid rent from January, October, etc., or anything, at the latest by January 31st. If the tenant fails to at least pay 25% of the unpaid rent by January 31st, then by February 1st, that is the first opportunity to file unlawful detainer. By that time, AB 3088 is behind us. The tenant must pay the full February rent, and you may be pursuing an eviction at that time for the unpaid previous rent as well as February's rent. On the other hand, if a tenant does pay at least a 25%, and for miraculously they pay February's rent in full, then they're good. But what about the unpaid 75%? Not until March 1st of that same year, March 1st of 2021, that's when you're going to foresee an avalanche of owners filing small claims court proceedings to pursue that unpaid rent. Now, luckily, the caps or anything for small claims court has been raised for those owners, so they can pursue higher amounts. And for at least the next 4 years, they can file multiple small claim courts filings against them. So there's a bit more, I guess, a leeway and flexibility or anything in that regard for March 1st.
Should everything stay intact in terms of laws, and we know they're changing, there is somewhat of a plan for the owners. Now, I guess the next big question, which everyone's been asking me, and maybe you have some insight, is everyone's under the assumption that the eviction moratorium will be extended through the end of 2021. What are you hearing, Oliver?
There is language in AB 3088 to actually extend the eviction moratorium if need be, albeit after March 1st of 2021. So there is, I guess, a legal framework or anything. Already within existing law, AB 3088, should that be necessary. Now with the vaccines that are currently online and being distributed, who knows how that will affect the sentiment of our local and state representatives. But nonetheless, there is the framework if need be, but on the other hand, the way AB 3088 is written, it's more or less written to put a bit of closure, if you will, albeit with a bitter taste in many owners' mouths or anything, to this unpaid rent. The closure being, or pursuing the unpaid rent March 1st over the next 4 years or anything, and presumably things should be back to normal at that time. But nonetheless, again, there is that context, AB 3088, if need be, to extend the moratorium. So they have given themselves, the representatives, a bit of a loophole if not necessary.
Which obviously, if it is delayed, that means all these unlawful detainers would then be consequently delayed as well. All the ones that were in line.
Yeah, and it's likely going to be in the same context. I guess this is a silver lining or anything. Though it shouldn't be too radically different than the current moratoriums. As many owners have seen throughout 2020, for example, we had a moratorium ending on, I believe, on July 31st. That was pushed forward to October 31st. Now we're looking at January 31st. But nonetheless, or anything, these moratoriums or anything, didn't change or anything, format or anything. In terms of the context of the moratorium, what the prohibitions are, what the restrictions are, that did not change or anything, throughout the year. So if the moratorium is extended in 2021, at least owners should be looking forward to what's largely been in effect throughout 2020.
Oliver, I know you take a lot of calls from what we consider, I guess in our industry, we call them, mom and pop property owners. And I know a lot of the folks that I service are what I consider blue collar. They self-manage their units. They've been working really hard. They took the risk 30 years ago to make this investment. They're out there fixing any leaks that the tenants call it. So this is the persona of who I service. Okay. What message are you hearing from them? I mean, it must be really difficult for them to try to navigate these waters, but what are you hearing from them? Are they fed up? Are they ready to sell? Are they ready to leave the business of apartment ownership? Like what's the overall feeling that you're getting from the people that are calling you?
As you can hear in the background, the calls are certainly ongoing or anything, but as long as I've been counseling property owners, I've never heard, I guess, whether those who are actually selling the property, asking questions about the logistics of selling the properties, or those are just expressing frustrations and making very difficult choices or anything. Certainly there have been, ups and downs. We recently had a housing crash, or anything, a few years back or anything. So we've certainly seen ups and downs in the industry or anything. But I guess the level of, very difficult choices, whether it be leaving the state of California, selling my property, relocating my real estate interests out of state, those very difficult questions have been much more, more prevalent this time of the year, certainly.
And, we appreciate you guys being kind of the main source out there, advocating for apartment owners, which, there's a big misconception that the apartment owners are these big corporations, which that is not who I talk to on the phone. I talk to folks that are bought real estate, bought apartment buildings for one reason. That was to be able to supplement their retirement income when they retired. A lot of these folks are up there in age, and it's been difficult for them to keep up with all the changes, keep up with all the new forms. And now on top of that, there's this eviction moratorium that's made it really difficult to manage their building the way that they would like. So we certainly appreciate, where can apartment owners get more information? I mean, even just right now with the quick questions you gave me, there was a few things that even I was unaware of. Like, what can an apartment owner do to stay up to date with all the changes that are happening?
One thing I would say is read. Simply reading anything. Now that begs the question, what do I read, or where do we get this information? So,
Right.
Whether it be talking to your local apartment association, they will certainly let you know that these are the sources that I'm researching. These are the places that you should be looking for information. This is where I'm getting my information. So more or less, owners are in the loop. And the ones that are a bit more familiar with, the lay of the land, if you will, they can do their own research, then come back to the apartment association for a bit more clarification, a bit more feedback or anything. So that's more or less my style. I like to educate people to educate themselves or anything, though. So that when they're a bit more educated, they can come back to me, we can have a bit more informed dialogue and then develop from there. And just to go back to your earlier response or anything, yes, many of these, I would say the vast majority of my phone calls are mom and pop owners. These are individuals who they themselves, hey, me and my wife, I work in this industry. My wife's a teacher or a nurse, for example. We tucked away our money for a number of years, sometimes even decades, to purchase this property. And we've been doing things a one way for many years, for example. All of a sudden, we're knocked off our feet by this kind of changing whirlwind of laws or anything, though. And like I said at the beginning of this conversation, more or less getting orientation or anything, what are these laws or anything, at the state level, at the local level? What can I do as an owner, and what are my tenants' rights that I should be respecting at the same time?
Outside of the eviction moratorium,
Yeah.
and then outside of the rent control, is there any other questions like, hey, Juan, I always ask this question?
Well, right now, especially with what's going on, sale of the property. So many individuals are they're misinformed, thinking that the sale of the property will somehow change the nature of a tenant's contract. Case in point, I'll get a call, Oliver, I'm selling my property. How will this affect my existing tenants? Well, actually it won't. Right? The property can change hands and the tenant's existing protections, whether it be under AB 3088 or the local moratorium, will not change. Then they'll ask, well, Oliver, what if I'm going to move in, for example? Now, let's highlight that. When they say, Oliver, what if I want to move in, or I want to move in either my daughter or even my wife, for example, they're referring to a no-fault allowance under AB 1482, the law that came out in January 1st of this year. Right. So that comes up as well, I think. More or less, owners figuring out ways to gain possession of the property. That has been probably the chief question, Oliver, or more or less another provision for AB 1482, substantial renovations. So many owners are all of a sudden they have a need to do major renovations or anything. Got sure. The kitchens, do this, do that, or anything. But yet, there's a caveat under AB 3088. These renovations or anything must be due to either a health or a safety reason. So this is more or less an upgrade or aesthetics or anything. It's not good enough. So many of them are waiting till after AB 3088 expires. Again, that's January 31st. So February 1st, you may see many owners kicking off that renovation plan, using that 60-day termination policy to terminate their contracts. So that's also a very popular question, again, within the context of getting my property back. Again, we mentioned rent increases. Many owners are waiting until after AB 3088 to the rent increases. But more or less, you get some, nuisance questions as well, So in Los Angeles County, there is a degree of protection for, low-level nuisance issues or anything, And these are nuisance issues that are associated with COVID-19. So during COVID-19, for example, many kids are staying home from school, for example. People are working from home. And I received many calls about nuisance issues about that or anything. People working from home, they're not accustomed to a higher level of noise or just being out of the office more or less or anything. And those complaints ensue or anything, There is protection within the Los Angeles County moratorium against those nuisance issues evolving to an unlawful attainder or even being the matter of a termination. On the other hand, if there are, significant nuisance issues, for example, an unauthorized occupant or anything, in some cases or anything, that can result in an unlawful attainder or anything, But again, although these nuisance issues, and again, these are substantial nuisance issues or anything, smoking, very blatant material breaches of contract, you serve a notice to perform, for example, for 3 days. So it's not a 15-day notice or anything for nuisance issues. It's only a 3-day notice. Okay. So case in point, a tenant is smoking or has an unauthorized occupant. You serve a notice to perform for 3 days. 3 days goes by. Now, if this is a rent control property, what I mean, a property under California rent control, AB 1482, it's a duplex or above, you're going to give them a second notice to quit. So a total of 6 days, 3 days to perform. If not, 3 days to quit, a total of 6 days together. Now, if the tenant does not vacate the premises by the 6th day, by the 7th day, you can begin the unlawful attainder process. But like I said earlier, even with that in motion, you're still looking towards at least February 1st for that to go forward. If this is a property exempt from California rent control, a single family home, for example, 23 days, 3 days to perform. If not, by the 4th day, you begin the unlawful attainder. But again, likewise, you're looking towards February 1st. So unfortunately, traditionally, during the holidays, the unlawful attainder system is a bit slowed down in the court system. You couple that with COVID-19, so we're looking at a considerable and the bottleneck of many owners, filing suits at this time or anything. So you have 3 factors that are really slowing down the court system. So although I say February 1st, we could even foresee even March 1st, for example, for things actually going forward.
And so there was a lot to unpack there. One question that I have, because people do ask me, and you brought it up, and I guess if you could just shed the answer that you give folks is, I'm going to occupy one of my units. Can an owner get possession of a property should they occupy one of the units? What's the answer for that?
Outside of Los Angeles County, yes, they can. So you're in Orange County, Riverside County, no problem in doing that. So now, here's the thing. Although there are moratoriums in existence right now, Los Angeles County has a provision against no-fault reasons for a termination. An owner occupying a unit is a no-fault reason. So at least until January 31st, that's on hold. Outside of Los Angeles County, not a problem or anything. So many owners are using just that reason to occupy their units. Within Los Angeles County, many owners are waiting until February 1st to execute that termination process.
Because one of the distinctions is, we're in Long Beach, and I know some of the references today, you said Los Angeles City, then there's Los Angeles County. Obviously, Long Beach is part of LA County, but when you say LA City, it appears to me that they have stricter laws when it comes to landlords. Is that a safe assessment?
Yes. So right now, LA City is more or less the outlier in terms of COVID-19 moratorium. So case in point, there is an existing lawsuit being filed against them by AGLA. So again, so that's probably a very extreme example. And again, there is no definite endpoint. So, whereas the Los Angeles County moratorium ends on January 31st, Los Angeles City has no definite endpoint. And if you look at the moratorium, I believe it says almost verbatim when the local moratorium or rather the local emergency period is lifted. So that is really at the local representative's discretion.
Okay.
So now you mentioned Long Beach, for example. Many cities within Los Angeles County, they more or less blaze their own path. They have their own moratorium. So Long Beach, for example, does not have that no-fault prohibition in the moratorium. So an owner in Long Beach could occupy their property by either themselves or their wife, for example, or their child, using the provision from AB 1482 to do that. But an adjacent city, for example, maybe the city of Lakewood, for example, using the county's moratorium, that wouldn't be allowable.
So in the city of Long Beach, an owner would be able to get possession of their property if they wanted to move in. And it's also safe to say that Long Beach is a little friendlier to landlords when compared to LA City. Is that correct?
Certainly, anything. And again, LA City is the outlier. And I would say LA City is the outlier compared to other cities in the county, certainly, whether it be Whittier, Bellflower, etc. I mean, again, this is the only city that has an indefinite endpoint of the moratorium and has an existing rent freeze. So certainly the most aggressive of the bunch.
So it's quite possible, Oliver, that if the moratorium gets extended, it's quite possible that landlords out there are sitting on buildings that they've not collected income for 12 months or more. I mean, that's a possible situation, correct?
Yes. And I have received those calls where they're going back since the beginning of this entire epidemic or anything, going back to March or anything when the state of emergency was enacted since that time.
Okay. Oliver, I know your phone's ringing. Is there any advice? People are looking forward to 2021. They're trying to figure out as a business owner, as an apartment owner, what should I do? Is there any advice that you have for them out there?
A couple of things, So in no random order.
Sure.
Now, owners are accustomed to, when receiving payments, applying it towards the oldest payment first and working their way forward or anything. At least until January 31st, for the purposes of AB 3088, you're going to apply the payments either on the month that's written on the check. So if the tenant writes December on the check, of course you apply it towards December, or if there's nothing written on the check, the month that it's received in. So if I received this in December, nothing's written on the check, I will apply it towards December. And this is more or less for accounting purposes for AB 3088. So you're applying the proper amounts towards the proper months or anything. Another thing, and again, this is more or less a business decision for many owners or anything. Going forward in 2021, it's being suggested that if you're going to do a fixed term lease or anything, so a fixed term lease, many of us are accustomed to doing a 1-year lease or anything. It's suggested to do it maybe for a 11th or even a 10th month period. One reason, for example, is AB 1482. Tenants that occupy units beyond 12 months, and this is for a subject property, these tenants gain just cause protection. So this is after the 12-month mark or anything. So many owners are saying, let me cut it short. Let me stop it at maybe 11th month or 10 months, more or less. And if things work out, I'll go to month to month. If not, I'll stop the contract right then and there. So you're looking at shorter contracts for landlords, more or less going forward with caution, if I would say or anything. Whether it be a month to month, whether it be a fixed term lease or anything, taking it step by step or anything, taking it whether it be for 6 months, for 10 months, under a year, seeing how things work out. So if things go awry or anything, not being necessarily stuck with a tenant or anything that's accruing unpaid rent or anything, especially if there's an extension in the moratorium in 2021.
Okay, that's a really good tip. Thank you for that. And was there a third one, Oliver? I wasn't sure if there was.
Working with your tenants or anything. Right now, although there's a constellation of laws out there, anything more or less or anything. There's AB 3088, there's payment plans, there's a 15-day notice, and it's more or less it's kind of overwhelming for owners or anything. What I've seen in the mix of this is owners that have a degree of rapport with their tenants or anything, able to work things out with their tenants. Now, more or less, this assumes that the tenant has demonstrated that they're for example, they're paying on time. You haven't had any violations from them, and more or less, it's been smooth sailing for the most part with this tenancy. Now, I guess a word of caution: if you're going to extend any sort of leniency or any sort of grace to the tenants or anything, be consistent or anything. Though there should be merit-based for the most part. For example, this tenant, for example, has had no non-payments of rent or no late payments for an entire 12 months or anything. Though, so for them, I'm going to extend certain benefits, for example. Okay, that's non-discriminatory. So I guess a word of caution. But I've seen owners more or less working with their tenants or anything. Even in the mix of all that's going on. So if need be, if you have a tenant that is working with you and it's being very transparent, things certainly work with them. It's a heck of a lot better than filing a lawsuit later on.
Okay, that's terrific. So let me go over those three. One of them was applying the rent to the month that it was received. The second one was maybe recommended to go month to month or something less than 12 months on a year. And then 3 is working things out with your tenant. And if you do, be consistent with all the other tenants so that you're not, so that's terrific. My advice to owners out there is to join the apartment association, use the forms that they're providing us, donate to the apartment association, and then you'll have access to experts like Oliver and the rest of the staff there that helps us out and looks after us. I know a lot of apartment owners have these old, outdated leases because I see them during the sale, and I always tell them, join the apartment association. They're on the landlord side, and making sure that we're doing everything that's correct and making sure that it's fair to the tenants as well.
And let me add this, Rita, just very quickly. You mentioned the lease contracts. The Apartment Association has recently released a 13-page new rental agreement. So it's a very comprehensive. So certainly that's one of our member benefits. But just a quick tidbit: there are 4 essential documents that every new tenancy should be adding in their contract. So just very quickly,
Sure.
One of them that I mentioned is a property is either subject or exempt from California rent control, or rather the California AB 1482 legislation. Properties that are subject to AB 1482 are duplexes and above. Properties that are exempt are single-family homes, townhouses, and condos. So depending on whether you're subject or exempt, you're going to give the appropriate addendum to your agreement. That's the first essential document. The second essential form is the flood hazard disclosure, the flood zone disclosure rather. Now, when this came up, many owners were a bit confused about this, and more or less, this is something that you would know you would know explicitly. Either your lender requires it, either your insurance provider requires it, and the realtors are also required to disclose this to you upon the sale or transfer of the property. So it's not hidden information. So that's the second document, the flood hazard disclosure. Okay. The third one is the bed bug disclosure, more or less indemnifying you as an owner of any damage that the tenant may ensue from remedying any bed bug hazards. And more or less, it puts the responsibility and the onus on the tenant should a bed bug infestation occur at the property. And the last one is a Prop 65 disclosure. Prop 65, you're more or less notifying tenants or anything of what the EPA considers the 2 toxicity points. One of them being cancer, the other being chemicals causing reproductive harm. So these are the, that was the Prop 65 addendum. So these are the 4 essential documents. Again, that's the AB 1482, whether your property is exempt or subject. The second one is the flood hazard disclosure. The third one is the bed bug disclosure. And the last one is the Prop 65 notification. So 2 of these are contained in the new Apartment Association contract. But again, whether you're using our contract or any others, make sure that these 4 documents are included in your rental agreement. So.
Okay, and you said that the new 12-page contract that you mentioned that the Apartment Association now has, are these 4 included within that 12
So
page?
2 of them are included in everything, because they're very short and they're very easy to include in the contract. The other two are much longer. For example, Prop 65, that's a 4-page document, so that's a separate document,
Okay.
as well as the AB 1482, whether your property is exempt or subject. So those two documents are subject, but the other two, the flood disclosure and the bed bug, are contained in the contract.
Great, great. Well, that's a good benefit for our clients to know, because I'm confident that not everyone's using the right forms, and it's a shame because you guys are the terrific source out there, and like I said, I encourage all apartment owners to be a part of the apartment association, make us a stronger group, and provide the best housing we can, because at the end of the day, that's the goal. So Oliver, thank you so much for today. I'm going to come up with even more questions, so hopefully you'll join us on a later date. But thank you for your all your help and all that you do for us.
Yes, I want to thank you, Juan, for inviting me this morning. I want to thank everyone who will be seeing this video or anything. And again, this is one of our member benefits here at the association. I look forward to talking to you about your landlord questions, your tenant questions. So again, thank you for your time this morning.
So one of the main things in every apartment owner's mind is the eviction moratorium. It's set to expire January 30th of 2021. The biggest question that we are getting is that going to be extended? When they wrote this piece of legislation, they gave themselves the right to extend if it need be. Now, one thing that Oliver did highlight is that with the vaccines coming out, hopefully this summer everyone should have access to it. That might help put a pause on that extension, but we're not 100% sure yet. But that will certainly continue to impact us for the next 6 months. So there you have it. Oliver did a terrific job highlighting the frequently asked questions that he's asked, throughout this year. He even touched on 3 tips moving forward, 3 tips in terms of recommending what you should do as an apartment owner when either renewing a lease, letting it go month to month, or just not even doing a one-year lease. And he also talked about the 4 new forms, disclosures that are now mandated by the state and are required. So I hope you guys enjoyed this interview. Thank you for tuning in. As always, every situation is different, so if you have any questions, please feel free to reach out to me, Juan Weezart, Sage Real Estate, or the Apartment Association. They're a terrific source, and I encourage you all to become members. If you like this video, make sure to like, subscribe, or comment down below. I'll see you next time.